I will now hand over to Ms. Joke Aliu, a moderator, who can spell out the rules of the debate and also give us some more information about the topics to be talked about. Thank you.
Yes. Good afternoon, everyone. So I am really happy to be here and to be co-moderating this session with Baba. So let me give Baba time to come up as well. So really, this is really a light-hearted debate. It's nothing too serious. And you know, someone once said, okay, well, maybe that's why we are sitting in between the two camps. You know, someone once said that it is better to debate an issue without settling it than to settle an issue without debating it. So I know that for many of the topics we'll be talking about today, we already have our individual positions on the topic. But I would say, you know, let's open up our minds, let's give them a chance. The purpose of this debate session is really to spice up the entire program, but more than that, also to give us some, you know, sort of balanced view about the subject. So just like with any other debate, we have a few ground rules for this debate. Rule number 1, each speaker has 10 minutes. 10 minutes. Rule number 2, so we have 4 sessions, I didn't say that. We have 4 sessions, and we have 2 speakers for each session. Each speaker has 10 minutes. Rule number 2, at 5 minutes, a green card will go up. At 3 minutes remaining, an orange card will go up.
I issue the red card.
When time is up, you will hear a bell or something that sounds like a bell. Yeah. And your microphone will be cut off. So let me hand over to Baba to introduce the first topic. Thank you.
Thank you very much, Joke. A friend of mine once said 4 o'clock is evening. I still think it's afternoon, so I say good afternoon to you all, ladies and gentlemen. This is the last session for this year's conference, and I must say that, Olu, you've done an amazing job again. Well done to you. Kudos to the whole team. Okay, it's been fantastic. I only came in this morning and I didn't expect anything less. I stood here last year, like these guys. I had to debate with, Oke was on my team. I was fortunate to have him. We had Dr. Gamawa, and then we had Afam Osigwe, and I mean, we knocked the hell out of the other guys. So, I wish you both the best. Joke said it's lighthearted. I'm not sure. I think Joke and I actually set the rules. The rules will change midstream, and depending on how the crowd feels, we could then decide again to change the rules. We both hold the gavel. There is no mace. Ladies and gentlemen, to start off this afternoon with our debate session, you've got 4 topics listed. And the theme of this conference is how we bring down the barriers for intra-Africa trade. You've got some of these guys that are probably going to try to convince you why we shouldn't. And you've got another set of guys who will try to convince you why we must. To start off proceedings, if I may introduce the first topic, which is, should there be ladies at the bar? My lords, my ladies, ladies and gentlemen, I am going to call on Paul Daudu to start off with the argument Against. Ladies and gentlemen, Paul Dowden.
Has my 10 minutes started counting? Yes. Good evening, distinguished ladies and gentlemen. Good evening, moderators. Good evening, able timekeeper. And good evening, audience again. You're the judges. So thank you very much. I appreciate this is a very sensitive topic. It is indeed a topic that seeks to question old traditions of the bar, where our female legal practitioners were referred to as gentlemen in skirts. And by extension, female judges are referred to as my lord instead of my lady. Recently, this has been reiterated by our current CJN, who has issued sort of a bench direction that female and male counsel appearing at the Supreme Court should be addressed as esquire. So it still remains. The question definitely brings an interface between the feminist movement and the legal profession. I am of the view that the emphasis should not be on gender. Rather, the emphasis should be on whether we have competent barristers, solicitors, and attorneys capable of meeting expectation of their clients. So I am definitely against the motion. Although I must concede without hesitation that the sentence "there are no ladies at the bar" indeed had a negative connotation due to common law traditions which we've inherited. But later on, women were allowed to practice law, and certain negative stereotypes, I agree, exist within our profession, and female lawyers have to battle with this, which is depiction of ladies as frail, indecisive, weak, lacking assertiveness. No, these are the stereotypes. I'm being real. But for me, I'm coming here to argue from the position of radical feminism, which is that if any female needs anything, she needs to legitimize herself and validate her existence by what she can do. She shouldn't be defined by her gender. And someone like Chiamanda Ngozi Adichie, who is a writer and a very strong advocate of gender equality and feminism, recently attacked Hillary Clinton for her Twitter profile. In her Twitter profile, what was the issue? She had, first and foremost, wife on her profile, and we all know Hillary Clinton's CV. And she had issues because she compared it to Bill Clinton's CV, where you saw things like former president, attorney, lawyer, and she was of the view that Hillary Clinton was selling herself short, and her gender didn't define her, but rather her competence. So I'm of the view that the figurative expression that there are no ladies at the bar has never stopped us from making progress. We have produced our first female Chief Justice of Nigeria. It has not stopped us from producing a president of the Court of Appeal, who is a lady. I can roll off the top of my head several female legal practitioners that have been heads of courts. We have several leading lights in the profession, such as Madam Sholanke Eseyen, Fuke Adekoya Boma Azobia, who is the former president of the Commonwealth Lawyers Association, Nella Andem Rabana, Mia Eseyen. There's so many. The issue is, can we actually improve female engagement and participation in legal practice, especially getting to the echelon and the top? That is the question, not whether you're a lady. That is what I feel the emphasis should be. We should tackle the root causes affecting the effective participation of our female colleagues and removing those hurdles that prevent them from reaching the top. For me, being a lady or being referred to one does not guarantee gender equality or convey any innate advantages to females. For me, to merely be a token gesture, an immense double-sided rhetoric to call you a lady, and we have not proposed the individual and institutional strategies to push the profession forward. So it is better, as a female, let me propose about 3 strategies. How much time do I have? Okay, I still have time. Okay, it's better if, as a female, you are prepared. What do I mean by being prepared? If you are to overcome what is before you. if you're making a representation to a potential client, have you taken time to study the position, argue the matter? Because thorough preparation, for me, is the key to establishing your competence. You should always strive to be better prepared, not because you're a lady. If you're facing J.B. Daudu in court, if you're facing Wole Olanipeku in court, if you're facing Funke Adekon in court, it's not because you're a lady you win them. The idea is, are you more prepared than your adversary? That is the question. So, and this will help you neutralize certain innate disadvantages you may face as a woman and help boost your confidence. Another thing is, be professional. Anticipate harassment or discrimination. And your response should always be professional. Your emphasis is, what is the client's instruction? Stay focused and try and achieve it. By staying focused and determined, you will always know how best to react. Then always try adopting a style that is not yours or unnatural to you. You may have a leaning towards corporate practice. Then what are you doing in a law firm, for example, like Falana and Co., which is more human rights and constitutional based? You also have to identify mentors who align more with your style. And also, finding a mentor is very, very important. If you adopt these strategies, I tell you, women will continue to attain leadership positions in our profession, and they will reach the highest and uppermost positions in law firms, at the bench, and at public organizations. But being a lady in itself does not give you that edge. You must be professional, you must be competent, and you must be a good attorney. Thank you very much.
Please, let's give him another round of applause. So, arguing for the position that there should be women at the bar is Tope Adeyemi.
Good evening, everybody. A judge once said to me that when you have nothing to say, you often change the subject. And that's... And regrettably, that seems to be what's happened here. Let's redefine the parameters of this particular debate, ladies and gentlemen. What we're talking about here is not complex. In Nigeria, we have a particular notion that there are no women at the bar, and it manifests itself in court, most notably when female judges are being addressed. And they're not referred to by reference of their gender. So a female may well be addressed as my lord, him, his, etc. And it harks back to this idea that there are no women at the bar. Now, I propose that this practice is antiquated and we need to ditch it. And I'm going to give you 3 reasons, ladies and gentlemen, why I think this should be the case. Now, number one, it's actually destructive. Jokes aside, we know that women had a late start to the profession, and it's not because women didn't want to join. It's because we were discriminated against and we weren't permitted to join. Now, within that context, the idea that a woman cannot be identified by her gender further disenfranchises her and marginalizes her, and it undermines her self-esteem because it reinforces this idea that you're an imposter in the profession. If you want to come along, you have to be referred to as a man, and that's not acceptable. Now, the second reason is that it's actually pointless. It's been suggested that there are no men, there are no women, and actually I think what my opponent was saying is that you need to put yourself forward, market yourself, be professional, and ultimately everything will work out. But again, that distracts from the point. If you have a practice that serves no purpose, why on earth are you going to hang on to it? In 2018, the Nigerian bar is trying to promote itself at the cutting edge. Here are to be found lawyers who are the smartest, the sharpest, the most effective. Within that narrative, there's no place for archaic legal practices and conventions that serve no purpose. So it's pointless, and it needs to be ditched. The third and final reason is that it reflects very badly on Nigeria. We've talked about the fact that we're trying to attract individuals to this market to a degree. And the only way you can do that is if you maintain credibility as a profession. Now, maintaining credibility does not involve holding on to practices that, as I've said, serve no purpose and that are pointless. Imagine this. You have particular investors. They want to do a deal in Nigeria. Now, I'm not suggesting that they would hear that we have this practice, that there are no women at the bar, and that would put them off. But it doesn't set the right tone. They will wonder to themselves, if the Nigerian bar are doing this, what else are they doing? What other funny practices have they got hidden away? Do we really want to do business in this place? And this particular meeting was opened with a poem that was blistering. And the poet said, "Let us be the African lawyers of the future, a new kind of African lawyer." Now I ask you this question: does the new kind of African lawyer address a woman as a man and say that there are no women at the bar? I'd say they don't do that. Therefore, we need to put this aside. So to conclude, ladies and gentlemen, of course, there should be ladies at the bar. Thank you.
Baba, do they need to vote?
Joke, I think you and I should take this on further.
Really?
So that we mix it up a bit.
Okay.
Right of rebuttal.
All right.
What do you guys think? So, but we need to put it to a vote. Paul, hard. You had a very difficult job, honestly. I didn't envy you when I saw the topic. It reminded me of the same topic they gave me last year, okay, you remember? And the whole room was against me, but I won, didn't I? So, Joke, let's put it to a vote.
Oh, yes. I have just one point to make. All the women at the bar in this room, please raise up your hands. Are there women at the bar?
And all those who believe that the legal profession should be gender neutral. No Bobriskis here. No shims. No gender sensitive issues. Because we have set the pace. We have set the tone. We have the particular distinct nomenclature for how we refer to our lawyers. You are my lord and you are he. All those in favor that we should not change the way things are and that there are no ladies at the bar, can I hear an aye? The ayes have it. I told you guys. Joke, let's introduce the next topic.
So in the course of the program, can I have your attention, please? Thank you. So in the course of the program, a lot has been said about the African Continental Free Trade Area. Starting from the speech of the Vice President. On one hand, we have those like the NLC and the Manufacturers Association of Nigeria, who feel that we should have, further internal deliberations before Nigeria accedes. On the other hand, we have people like Baba. I don't mean you, Baba. I mean Baba, former President Olusegun Obasanjo, who is of the view, who is disappointed that Nigeria is not one of the 44 that signed the agreement. So this afternoon, we're going to be inviting Ikechukwu Ibauchi, yes, to take the argument against accession to the agreement.
Good evening, everybody. I'm going to hit the nail on the head. My name is Ikechukwu Ibauchi. I'm a business analyst. Since Wednesday, we've been hearing all about the AFCFTA, and we've been hearing all the good things about the AFCFTA. I'm here to break your hearts. I'm sorry. So the first thing is, the AFCFTA is a good idea. I remember back then when I tell my dad some things, he would say, Odimma. But deep down in his mind, he has his reservations. He knows somewhere along the line I would come back. That's what the CFTA is. And we have to face the reality. The first reason I have why we shouldn't even consider it as a country is regulations and enforcement of regulations. You see, we have laws that's established. Are laws being enforced the way they're supposed to be enforced? Not really. No, really. The customs, for example, our borders are porous. You would go to a car mart where they have lots of cars, and you ask, why is this car more expensive than this one? And they say, because this has import duty, this doesn't. Some months ago, the vice president, who was acting president at that time, made an instruction to all enforcement agents at the ports and airports, borderways, that in a view to easing the business environment, some agencies should leave the ports. Guess where they are now? They are back to the ports. And you ask yourself, why are they there when an instruction was given for them to leave? Because the enabling laws establishing these agencies basically allowed them to do their jobs. So they are doing their jobs. You can't stop them from doing their jobs. So the first thing we have to consider when we're going into the CFTA is how strong is our regulatory and enforcement arm? Not very strong. Is it strong enough to handle the surge of goods and interests that would come into the country once we get on the CFTA platform? No, it's not. If we go in at the moment, it's going to be a slaughter, because by the time we understand what's happening, our markets will be filled up with goods from other markets, and we will not be able to handle it. This is something that we cannot hope our way into. We can't pray our way into it. So it's either we're ready for it or we're not ready for it. Policy development and creation. We have a lot of policies. I'll give you an example. And this is a good example, so it's going to help my opponent. The Ministry of Industry, Trade and Investment have in development what's called the backward integration policy. And it's supposed to help industries in a particular sector backward integrate. So a company can assist another company and produce a particular element of its product. Now, it's a good idea. And it was only recently that they started talking to the manufacturers themselves. And that's something that hasn't been happening for a long time. And I would commend this administration. It's starting. I'm a member of the NASBA Working Group on Trade, and I will tell you that getting the private sector members involved in the discussion, in the creation of the laws that govern business, because these are people who are on the ground. They do the business. They know what works and what doesn't work. It's not a top-down approach. You bring in the people who are involved in this thing, and they tell you how it is. And we craft the laws to suit that purpose. And then going back to regulation really is, we really need to consider our laws. We have a lot of options in our laws. If not this, then that. So you have a lot of loopholes. I am a strong supporter of the notion. It's either you follow the law and you follow the instructions, or you go home. We have a lot of options in our laws, so there's always a way to move around these things. Now, how can we solve this problem? How do we sort ourselves out if we don't get into the CFTA? It's simple. We follow the Chinese method. So what we do is we look inward. Now we understand the CFTA, we understand what it does, we understand what it is, really. So what we do is we set up a plan. We look inwards, we build our industries, we solidify, we strengthen ourselves economically. It's not about pride, it's not about our position in Africa as leading trade market, it's not about that, it's about economy. It's about the long run, what's going to happen in the long run. So when we do that and we recognize our position, coming from a position of strength, what's going to happen in the long run is we find ourselves in a position where we can say, okay, we are out of the CFTA, and then we've observed the market, and then we can have an agreement with a country operating in the CFTA, and then now it's going to be a bilateral agreement, just one country in the CFTA. Now, what that's going to do is, that's going to allow us access into the dividends of the CFTA, and at the same time, it's going to allow us to strengthen ourselves, stand strong, and maintain control of our markets. We have to remember, Nigeria, this is the truth, is a largely consumer-oriented market. We need to switch at least to have a strong point in production so that we take out as much as we bring in, or even more than we bring in. We export as much as we import. That's the position of strength, and that's why I think Nigeria should not accede to the CFTA agreement.
Before I introduce the next speaker, somebody's lost a bunch of keys. Please, if you found those keys, kindly just hand over to the organizers of the event. We'd really appreciate that. Trying to move on swiftly. We just had Ikechukwu Ibiawuchi try to convince us why we shouldn't sign the Continental Free Trade Act. Treaty. There's a man here with a lot of conviction. In fact, when he saw that there were two black chairs at the end of the stage, he said, I'm not sitting there, I'm on the winning end. Ladies and gentlemen, if I may introduce Mr. Kalu Abosi.
Baba, that's not how I recall that conversation, but I'll let it pass. Good afternoon, ladies and gentlemen. My colleague who spoke against this matter, he confused me completely. Last time I was in a debate was in the university, and the guy on the other side, it was some economic issue. The guy is former chairman of the Bauchi Bar. He just stood up and said, the superstructure of the economy has already bastardized us. I was thrown. He was confused. I didn't know what to say next, you know. Ikechukwu has managed to do the same without raising his voice. But let's go back to what it is we seek to talk about, because there's a danger that we're talking about two separate things. And I'll tell you two stories about where people thought they were talking about the same thing when it turns out they were talking about separate things. Back in the days of the military, a military governor visited a school, and he asked a boy in JS3 who wrote Things Fall Apart, and the boy said, I did not write Things Fall Apart. The governor was confused and turned to the teacher. I just asked this boy who wrote Things Fall Apart, and he said he did not. The teacher said, the problem is that this boy is an honest boy. If he said he didn't write Things Fall Apart, it means he was not the one that wrote it. The governor was nonplussed completely. He turns to the principal of the school. What is going on here? The principal said, I've been telling them to stop writing things. I don't know why they've gone to write Things Fall Apart. And he goes home to his wife and tells his wife what happened. His wife said, I've been telling you, it's your enemies. They've gone to write Things Fall Apart. In this case, they were talking about two separate things. Nobody was trying to deceive the other. One of my favorite US presidents is Bill Clinton. And he had this issue with Monica Lewinsky. And when they asked him whether he slept with Monica Lewinsky on that oath, he said no. And when it turned out he did have relations, his lawyers argued that throughout the time he was with Monica, they were awake. So there was no question of whether he slept with her or not. So what we are... And by the way, Bill Clinton is a lawyer. So what we're talking about here is not, so what I hear Ikechukwu say is that because our borders are lax, we are not going to sign on to this agreement. What we need to know, like we've heard, whether we sign this agreement or not, the rest of Africa is not going to wait. People are going to get ahead of us. We need to be aware of that. So the reason I say we need to dimension what we're talking about is to understand the consequences, to understand that it is a false choice that we are presented with. We have to sign the agreement. This is the first thing Africans have done for themselves to try to pull Africans out of poverty. Yesterday, on the front page of Business Day, there was a report that every minute, 6 Nigerians move into extreme poverty. So by the time I came to this podium and go down, 60 Nigerians would have moved into extreme poverty. This is an opportunity for Africans to trade amongst themselves, to open their borders, and to help each other to come out of poverty. Don't you see the boats, people dying on the Mediterranean trying to cross over? Does it not break your heart? Are you not concerned about that? This is an opportunity for us to do things right. This is an opportunity to pull the people of Africa out of poverty by our own effort. And, by our effort, like I say. The other thing, the biggest, one of the things that militates against progress is our fear that we are not good enough. I hear us say that people are going to swamp us. What of us swamping other people? Most of you here are probably familiar with the name Marilyn Monroe. But I'm sure a lot of you don't know that there was someone called Norma Jean before she became Marilyn Monroe. And, how did it happen? She was tall, and, her mother was committed to an asylum. And along the way, foster parents, this, that. She was actually an insecure kid. Although she was a very beautiful woman, she didn't know. Until one day she was going to school. And of course, the boys in school didn't talk to her because she wasn't popular. The girls didn't talk to her either because she wasn't popular. On this day she was going to school, her clothes was dirty, so she decided to wear an old sweater that was very tight. And that sweater emphasized certain assets, And suddenly, everybody was now friends with her. The boys were staring at her and smiling at her, and they offered to walk her home. Maybe the CFTA is the red sweater that is going to bring this. That's good. The red sweater is going to bring out the potentials we have in us to go forward past where it is we've been. We have the capacity to overcome Africa. And Chimamanda Adichie talks about the danger of a single story. Goods are not just the story we are talking about. Goods, they are not. The danger of a single story, is not that they are false, according to Chimamanda. It is that they are incomplete. It's not only goods we're talking about. We're talking about services. I went to speak at a conference in Nairobi. On the panel, I was the only Nigerian that came from Nigeria. The chief executive of a Kenyan bank was a Nigerian. There were 2 chief executives of Kenyan banks who were Nigerians on that panel. The deputy chief executive of Standard Chartered in Uganda, when I went there for a conference, was a Nigerian. You know it more than, and I find it amazing that it's young people who are actually dragging their feet about this CFTA. Don't you realize this is the opportunity for you to take over Africa? You think at my age I can learn French or Portuguese? Young people, you are the one who can learn French, you can learn Portuguese, you can learn Arabic. You can move into the world when this agreement is signed by Nigeria, because it has to be signed by Nigeria, and you are going to take over. You're talking about seniors not paying you enough. pardon me, African brothers who are here, some senior associates or even associates in some Nigerian law firms, if they do go to African countries, they're probably partners there. So if Nigerian seniors are not paying you enough, is this not an opportunity for you to go to another country? The young people here on Tuesday, as chairman of the Capital Markets Committee of the SBL, were at an event at the Nigerian Stock Exchange, an executive roundtable talking about an ASM board. I told the panel the story when we were preparing, that all the young people who came there, all the people who were there, all the chief executives were 40 and below. I had to tell the other people with me and my age group that, look, we need to start making our retirement plans. These people are about to take over. The CFTA is to the advantage of the young people in this room. I think you need to take charge, make it work, take advantage of the opportunities that are there. And the other thing I say about us not being able to compete, who says, I mean, we have more money than other African countries. Who says we have more access to capital? Who says we can go to those countries and set up factories in the place and distribute it to the rest of the world? There's a quote of JFK, another favorite president of mine, US president of mine. He says we should not allow our fears to keep us from pursuing our hopes. It will appear that our fears seems to be on the ascendancy, that other African countries are going to swamp us. Is our hope not that we should be able to have an opportunity to trade more with African people, that when there is no electricity in Nigeria, the Nigerians can go to other African countries where there is electricity and set up? It will be for the good of everybody. It will be good for the good of Nigerians. It will be good for the good of our African brothers. And finally, if you are waiting for the situation to be right, for infrastructure to be there before we can sign the CFTA, it is not going to happen. The infrastructure will never be there. Nigeria, I don't know whether you are familiar with the psychological term, focus dividend. When you focus on something, if you were like me when you were in the university, you didn't read until the exams came. When the exams are around, you don't focus. You see, and then you come to the hall and do it. All those who thought you were a non-academic student will be amazed at what comes at the end. This is the focus. When we sign this agreement, the Nigerian government will be forced to up its game to ensure that there is infrastructure and that our manufacturing sector will work better. There was a text message, a WhatsApp message I got yesterday, that when it comes to temptation in marriages, it's when men have money that they are vulnerable to temptation. And women are vulnerable to temptation when they don't have money. And that the solution to keep the devil away is that when men get money, they should give it to their women so that the devil will be away, nobody will be tempted. I don't know what you think about that, but it sounds to me like it is a practical solution to dealing with an intractable problem. Ladies and gentlemen, that's my bit. Thank you.
We're back.
Yeah. So do we take the votes?
Rebuttal? Vote? We vote.
Vote. Okay. For those in favor of Kalu Abosi, say aye. For those in favor of Ikechukwu, say nay.
Joke? I don't know. Should we go again? For those who accept and believe that Nigeria truly is the giant of Africa and does not need to open its borders to any small African country, I want to hear you say aye. And for those who think, really, Nigeria, things are just so difficult, I'm a senior associate, I want to make partner. Perhaps I go to Benin or I go to Togo, one of these small African countries, and we open up our borders, say nay. The nays truly do have it. So third session. Which will we pick, Joke?
let's do the pupillage.
Or self-regulation.
Pupillage, self-regulation, pupillage.
Crowd says pupillage. So earlier this morning, the Nigerian Law School and the educational establishments were being blamed for not bringing out the best products that come into our different offices. And so there's an argument here that pupillage in law should be mandatory and a cost to all of us. To argue for and in support of this argument is none other than Mr. Isaiah Bozimo. A round of applause for him, please.
Thank you very much. Distinguished moderators, fellow debaters, distinguished ladies and gentlemen, good evening. I will be speaking in favor of the proposition that there should be a mandatory system of pupillage in the Nigerian legal profession. And in inviting you to vote in favor of this motion, I will propose 3 issues why. The first is that we're confronted with a situation of falling legal standards. The second is that our legal education system is simply failing us, right? We are not exposed to the realities of real-world practice in our law faculties and in the Nigerian Law School. And the third is that though there may be some concerns as to what introducing a system of pupillage might entail, each of those concerns has a sensible solution. So when you consider these 3 factors dispassionately, then the irresistible conclusion must be that we should introduce a system of pupillage in the legal profession. So let me start with the first. Now, who here is concerned about falling legal standards in the profession? Just by a show of hands. Right, I agree entirely with you. Let's ask ourselves another question. Why are legal standards falling? And an answer I invite you to consider is that there isn't an adequate system of quality control at the entry level of the profession. What do I mean? It's too easy to become a lawyer. It's too easy. I understand and I accept that we should have an open and inclusive bar. But that concept will be jeopardized if we have a bar that doesn't give quality, right? Now, has anybody heard the phrase here, let my people go? Let me demonstrate how that works. Now, at the LLB level, the minimum entry to enter law school is the equivalent of a grade D, right? All you need to do is successfully complete the LLB and you're admitted to law school. It doesn't scrutinize between a fantastic individual that made a first class or somebody who simply scraped by with a pass. Let my people, exactly. Now, you get into law school an equally low standard. The bar is not raised. To pass law school, all you need to do is a pass. Again, equivalent of a grade D. And I like figures, so I'd like to address you on some real-world figures here. Now, in 2017, 4,284 candidates passed the bar finals. 4,284. How many first class? 29. 0.5%. 2-1 grade, 211 candidates, 3.6%, right? 2-2, 1,046. That's 17.8%. Pass, let my people go. 50.9%. 2,999. Now, if we consider a 2-2 to be a good grade, right, and we say first class and 2-1 is above average, pass is below average, then that would mean that just over 4% are above average and 50.9% are below average. Now, I understand, and again, I agree, that you can be a good student and simply bad at exams. You can have a bad day, yes, I understand, but I don't think that's what's happening here. And why do I say so? Because the data replicates itself year after year after year. So if we look at 2016, right, just over 20% made either a first class or a 2-1, whereas 53% made a pass. 2015, same thing, 6% above average, first class 2-1. How many below? 72.8%, right? 2014, even worse, 3%, first class 2-1, above average. Below average, 78%. So what does this tell us? It tells us that we have a system that encourages mediocrity. It says it's okay to be below average. Below standard performance at the LLB, it's fine. Come to law school, let my people go. Below average performance in law school? I spent 5 years in university. I now spent an extra 1 year. You don't want me to enter the bar profession. Let my people go. We encourage mediocrity. Now, here's the big difference. If you have below average performance as a professional lawyer, what happens? Legal standards will fall, right? It's as simple as that. Now, again, I understand the counter-argument that the bar and the system has in place a self-mechanism that checks lawyers that are unethical and unprofessional. But ask yourselves, what sort of bar do you want? You're the owners of the legal profession. What sort of profession do you want? Do you want a profession where year after year complaints to the LPDC are going up? What sort of image does that give us, right? Let me give another example. Lagos State Judiciary is attempting to eliminate its backlog, right, and conducted a study to find out what was causing an inefficiency in the system. In 45% of the time, it was the fault of counsel. So again, I'll ask you, what sort of profession do you want? Do you want one that places a premium on excellence? Or do you want one that says it's okay to be below average? I commend the second option to you. And I commend it because we are in an era where globalization of legal services is becoming inevitable. We can't escape it. You've heard about the Continental Free Trade Agreement. You've heard about the opportunities that it will present. Now, the big question is, are we ready? Are we ready to take advantage of those opportunities? I'm not quite sure, and that leads me to my second point, right? Do faculties of law and the Nigerian Law School expose us to the realities of practice? Again, I'll come back to you. Do they? Exactly no. Was anybody here in attendance at the Young Arbitrator Forum representative? And we did a program last week on effective cross-examination and arbitration. 120 people were in attendance. Almost 100 were on the waiting list. So you see a pattern here. And the pattern tells me that there's a gap between the practical knowledge that we have as young lawyers and where we need to be in order to be globally competitive. So clearly, the law school and the faculties of law are not preparing us for the realities of the profession. Now, I would be naive to stand here and say that there are no concerns. Okay, I see I'm doing so well. I've been given an extra 3 minutes. Thank you very much. Thanks. So I would be naive to stand here and say there are no concerns with introducing a system of pupillage. And I can suspect there are three concerns. Now, who here is concerned as a young lawyer that you will be mandated to do work without pay? Oh, okay, in that case, I see hands. I see some hands, right. Now, you needn't worry. Now, the instrument that seeks to introduce a system of pupillage, right, is the Legal Profession Regulation Bill. That bill seeks to establish something called the Legal Profession Regulatory Council of Nigeria. I'll just call it the council. And the council has several committees, one of which is the Remuneration and Welfare Committee. And as its name suggests, it recommends the minimum remuneration for young lawyers. And young lawyers, incidentally, is defined as any lawyer below 8 years post-call. So invariably, it will include newly called lawyers on the pupillage system, right? And you may have seen, or you may not have seen, there was an article in March of this year where the minimum recommended salary for a young lawyer was 50,000 naira. So it eases the financial concerns you may have. And again, I stress, that's the minimum. Now, law firms are competitive, right? They want to attract the best students. So invariably, they're within their right to offer over and above what that prescribed minimum is. Now, another concern might be, okay, well, who is carrying out this training? We don't want to be led by the blind. Again, the bill prescribes for that. Now, there is a system of qualification. So you're not automatically qualified as a lawyer to supervise pupils. You must satisfy the council, first of all, that you're in active legal practice and that you have the facilities and capability to give the training during the period of pupillage. So there isn't a system of automatic qualification. Now, if you juxtapose that against the objectives of the bill, that is to maintain public confidence in the legal profession and to ensure the legacy of the profession by continuing legal education, then it paints a picture that the bar is conscious of maintaining standards. So in order to qualify, you must meet and exceed those standards. And the third concern might be, well, it's simply inadequate. You look at other jurisdictions like the US, fantastic lawyers, no system of pupillage. Now, let's be honest with ourselves. The American legal system and the American education system is not the Nigerian legal system or the Nigerian education system. I'll give you another example. Now, there's a list of 300 top law schools in the world. 52 of them are in the US. None are in Nigeria. So, ladies and gentlemen, it seems to me that the proposition is clear. We should vote in favor of a mandatory system of pupillage in Nigeria. I thank you very much.
He was right on time. Let's give him another round of applause. You know, this morning, when we were talking about pupillage, I was trying to look at the younger lawyers, and I spotted a particular one whose, you know, his countenance was really angry. And then he looked at his friend and he said, "Oh boy, this pupillage thing, na scam o. Anytime we say make the increase salary, they go say we still the learn." So, you know, the truth is it really a scam, or is it really worth it? So let's hear from Cordelia Ike, who takes against the motion.
Good evening, everyone. While sitting there, someone asked me, why would you want to argue against pupillage? You know what is going on now, falling standards in practice and all. I said, there's a mistake. You're making a mistake there. I'm not arguing against pupillage. I'm arguing that it should not be mandatory. I'm arguing that we should not be compelled to go on pupillage. I'm arguing that law firms should not be compelled to take in lawyers and pay them what they cannot afford to pay even their staff. That is what we are talking about. Yes, we are all concerned, falling standards. Pupillage is desirable, but should I be forced to do it? What if I read law and I just want to be like Falls the bad guy? I just want to entertain. What if, I want to be like Omaomi? What am I doing in a law firm pupillage? We're talking about Nigerian educational system, fine. How many years? I was supposed to be called to bar in 1994, but I was called 95. Nobody was called in 1994 because there was strike action. So I spent 1 year extra. Then it was 4 years to graduate from the university. So now it's 5 years. We count the 5 years in university. That's minimum. Then you go to the law school, that's 1 year. 5 years, that's 6 years minimum, because it could be more if you're schooling in Nigeria. Then, of course, we talk about the NYSC, where you are given a stipend. And after that, compulsory pupillage. Young lawyers, is that what you want? Compulsory pupillage. And again, you are paid a stipend because they say you are still learning. How many law offices pay their juniors well? How many pay above 100,000? There are law firms that are paying 10,000 and 20,000. Yes, these are lawyers, are qualified lawyers. Then you ask them to take on pupils. How much are they going to pay them? So can our law firms handle it? 4,000 lawyers are called, well, let's say minimum of 3,000 lawyers are called to bar every year. Where do you send them to? How many law firms have the structure? How many of them have the space? How many have the capacity? How many have a department that can take on pupils? How many of these law firms themselves have a space, okay? Now, these law firms we're talking about, most of them are sole practitioners. Anybody opens a law firm. As secretary of the NBA, I had to attend to a lot of complaints. Lawyers posted on externship. They came and they were looking for the law firms that were posted to. Some of them were no longer in existence. We don't have an updated data of law firms. That's one. Then for some, they went there and they were rejected. So they asked the chairman of the bar, I saw my chairman some time ago, they asked him, please post us to somewhere. We just have to satisfy these requirements for the sake of the paper so we can be called to bar. Now, does that achieve the purpose it was meant for? So let's not talk about pupillage like it's a magic word. In Nigeria, we like to make everything mandatory. How about making it attractive? How about making people want to do pupillage? Yes. Now, let's take, I like to use myself as an example. You know, sometimes when I was in the university, every vacation, I found myself in a law firm, a commercial law firm. Then it was Serena Dokubo & Co. I would always go there and learn something during the holiday. So by the time I was out of the university, I already had an idea of the workings of a law firm. So during externship, I was in Judge Tommy and Partners. So that was me because I wanted to learn. I wanted to know what it was all about. By the time I was called to bar, I already knew something about the workings of law firms. Now in the Ministry of Justice, I work in the Ministry of Justice. Every year, lawyers are sent to the Ministry of Justice. At the time, they sent over 100 lawyers, and my Solicitor General went to the NYC, please, we can't handle this. We don't have space. We can't take in these people. So we let them go and find, you know, sometimes just find somewhere because we can't accommodate you. Of course, the state won't pay you. It's what NYC gives you. Now, I have to mentor some young lawyers. They assign sometimes 1, 2, or 3 to me. And I see the difference. Some of them come in during the NYC period. They don't want to know anything. They don't want to learn. The ones that want to learn, I'm ready to teach. And with that, some of them, before they finish, they already know how to conduct trials. These are lawyers that want to learn. And that 1 year is enough time for them to get enough training as pupils. They don't need another 1 year. So it depends on the individual. Do you want to learn or don't you want to learn? Yes, so now making it mandatory. Look, if anything compulsory just puts people off. I work in an office where anytime there's a meeting, they will say attendance is mandatory. Names will be taken down. And my colleagues just say, look, what is this? Why don't you make it interesting? Can I just offer another proposition here to both the lawyers, NBA, and then the law firms? Now, why don't we make this interesting? Attractive for a law firm. Look, if your firm takes on pupils, you get certain benefits. Now, people apply for silk. They told them you have to do pro bono matters. So everybody is going for pro bono matters. You know, it's helping us. So if you don't want to do pro bono matters, then don't bother applying for silk. It's not mandatory. It's not compulsory, but you take the decision. Look for other incentives why law firms should take on pupils. Now for the person that wants to apply. Is it not better for you? Is it not more, doesn't it make you more competitive if you get certification from a law firm that is regulated, of course, that is licensed by the MBA? Is it not more competitive to say, yes, I have gone through pupillage in these law firms? That way, you're looking for a job, and you have this to brandish. Of course, it's going to make you more competitive. That's why you have people that have LLMs, and they take trouble to, enhance their professional, the certificates given by the law school. You see that you go for jobs, and they beat you at it. So why don't we make it attractive and let people opt, to do pupillage rather than forcing it down the throat of everyone, oh, you must do pupillage. So these are the reasons why I feel we should liberalize this. You don't have to force people because our families are waiting. They want you to finish law school and bring money back. Yes. So you can't be going to school forever. Doctors are in school for a long time, but you know what? A government pays them. The government pays them because they work for government. Government cannot pay you pupillage while you are working for a private law firm. No, they pay the doctors because they work in government hospitals. And I don't think any owner of the law firm, anybody would want to be forced to pay a minimum wage, when he knows he cannot afford it. The economic situation is bad, and we have to do what we know we can manage. We shouldn't start something we cannot finish. Yes, pupillage is desirable, but should it be mandatory? Thank you.
We told you it'd get interesting. I mean, Mrs. Eke is used to being not the most popular person, being a prosecutor that she is. So handling such a difficult topic. I knew she could handle it easily. Can we have another round of applause for her, please?
You know, when I heard Isaiah, I thought, you know, it was a done deal. And then I heard, you know, her arguments as well, and I thought, well, that's really a good one. A round of applause, please.
Shall we vote? If we don't vote, then who's won? Is it a tie? It's not a tie. Joke?
Okay. So those in agreement with Isaiah say 4. Okay, do I repeat it?
Please.
Those in agreement with Isaiah say 4. And those in agreement with Cordelia say against. Against!
The against have it. So now we have our last topic for the evening. And I wouldn't say what I said about one of my friends earlier this afternoon when he wasn't around and we were discussing our topic. And I wouldn't also tell him what was said about him whilst he wasn't in the room when we were discussing the topic. But I'm sure you're all familiar with NBA versus Gani Fawehinmi 1 and NBA versus Gani Fawehinmi 2. So, should lawyers continue to self-regulate? Ladies and gentlemen, here, going against the motion that we shouldn't continue to self-regulate is my very good friend, a member of the bar, a leader of the Lagos Bar, Mr. Alex Muoka. A round of applause, please.
Good evening. I'm conscious of the fact that this is the final session and we stand between you and Davido, okay? But I want to start by asking, and let us be honest with ourselves. As we are seated here, if there is a charge of professional misconduct against Alex Muoka that would result in my being disbarred, and I would no longer be able to practice as your colleague, and my fate is in your hands, and a lot of you are my friends, I've done matters with and against you, would you really find it in your heart to vote to disbar me? How many of you would? Very few of you. Now, that is the crux of my thesis this evening. That we have always self-regulated, and should we continue to self-regulate? Now, let's start by examining the present regulatory architecture of the legal profession. And statutorily, there are certain bodies that have core responsibility for various aspects of regulation of the legal profession. First is the General Counsel of the Bar, which makes and reviews the rules of general conduct and the rules of our accounts. We then have the Body of Benchers, which is a body of legal practitioners of the highest distinction in the profession, with responsibility for the formal call to bar of persons who are aspiring to practice law. But also, the Body of Benchers has power to discipline members of the profession. We have the Nigerian Bar Association, which is an association of all of us who are members of the profession. We have the Council of Legal Education, which has primary responsibility for legal education, which of course owns and operates the Nigerian Law School. We have the LPDC, the famous Legal Practitioners Disciplinary Committee, which is a committee of the Body of Benchers charged with determining complaints against legal practitioners who have been accused of professional misconduct. We have the Legal Practitioners Privileges Committee, which, as you know, is responsible for elevating members into the inner bar. Finally, we have the Legal Practitioners Remuneration Committee, which is not very popular, but which makes rules or orders regulating the charges or remuneration of legal practitioners. Now, what is interesting about these 7 bodies is their membership. Because of time, I won't reel out the list of members of these 7 bodies. You're familiar with them. But I will make the point, the singular interesting point, that the membership of these 7 bodies is entirely and exclusively made up of lawyers. So we have decided that in regulating our profession, we will set hens to watch over hens. Now, the question is, has this worked? We've been operating this system for many years. And tonight we're trying to decide whether we must continue to do the same thing and expect a different result. Now, to put it in perspective, how do you think the public perceives us as lawyers? Are you concerned with how people view you? Of course, you know that the general consensus is that lawyers are very unpopular, and for many, many reasons. People believe that lawyers are difficult, and we create and complicate problems rather than solving them. People believe that we cost too much, and we really do not provide value for money. People believe that we are elitist. We pursue high-ticket transactions rather than providing legal service to the lower end of the society who are desperately in need of our services. Of course, people believe that we complicate matters by our archaic and esoteric language. Now, with this kind of perception, you can best imagine what the public feels about lawyers regulating ourselves. A survey by the Law Society of New South Wales in 2015 into the public's perception of the industry unearthed some surprising results. Now, 31% of the respondents in that survey believed that there is not enough regulation of the profession. And the same 31% of the respondents do not trust lawyers at all. Now, I'm sure you know that lawyers are the butt of a lot of unsavory jokes. You've heard the joke, people ask, how many lawyer jokes are there? And the response is, oh, there are only 3 lawyer jokes. All the other stories about lawyers are all true. Then somebody asks, how many lawyers does it take to screw in a light bulb? And the answer is 3 lawyers to screw in 1 light bulb, yes. 1 to climb the ladder, 1 to shake the ladder, and the 3rd lawyer to then sue the ladder company for his colleague falling down and sustaining an injury. Now, somebody then asks, now, what are lawyers even good for anyway? And they say, oh, lawyers are good because they show how bad used car salesmen are. And finally, we're asked, oh, what do dinosaurs and decent lawyers have in common? They are both extinct. Now, this is the way the public views us. But let's even leave the public perception. Let's interrogate this issue ourselves. Now, let's be honest. Has self-regulation worked for us? Today, the Nigerian Bar Association has, over the last 2 years, an increasing number of complaints and petitions about legal practitioners has come to it. Now, over the last 2 years, I checked, and currently there are under 50 charges that are currently going through the LPDC. Now, out of that number, over the last few years, how many lawyers have been sanctioned? And the sanctions include suspension from practice, a slap on the wrist, or debarment. Very few. Now, what is more worrisome has been the results in relation to sanction or regulation or discipline of senior lawyers, senior advocates. The public records are there. The first conferment of the rank of senior advocate was on the 3rd of April, 1973, and 2 people were conferred, the late F.R.A. Williams and Dr. Nabu Graham Douglas. Now, as of October 2017, the LPPC had elevated 479 distinguished legal practitioners into that elite club. Now, of this number, how many have been sanctioned? Now, only 5. Chief Michael Andwaka, Chief Jibala Rizala, and recently Dr. Joe Wobike have been suspended at various times. Only 2 senior advocates have ever had their ranks yanked from them. Otumba Kunle Kalejai and more recently Kunle Ogumba. Now, this record must be juxtaposed against the estimate of 120,000 lawyers who have been called to the bar over the years. So the truth is that it's not working. Now, we recognize that ourselves, which is why in January 2017, the NBA set up a legal profession regulation review committee to look into the problem. Now, I want to quickly point out how regulation is done in two other aspects. Accountants. Now, it may surprise you to know that ICANN has a two-tier regulatory system. If a complaint against a member, it's first referred to an accountant's disciplinary panel. If a primary case is established, it goes to the accountant's disciplinary tribunal. And tribunal has a chairman and 6 members, and it has the status of a Supreme Court of Record. The membership of the tribunal includes one non-accountant, a lawyer. Now, judges who are lawyers are regulated by primarily the NJC, the National Judicial Council. Now, what is the composition of that council? Are you aware that the NJC has 2 non-lawyers amongst its members? And those non-lawyers sit in the NJC to determine disciplinary cases against judges. So I ask, if judges think that it is good enough to have non-lawyers sanction judges, why do we lawyers think that we are best suited to sanction ourselves or discipline ourselves? Now, what should we do now? Now, I want to leave you with an oft-quoted aphorism. The definition of insanity is doing the same thing over and over again and expecting different results. Now, I didn't say that. The greatest mind who ever lived said that, Albert Einstein, and he wasn't a lawyer. So I submit to you that it is time to end self-regulation of lawyers. We should embrace the reality and rejig our regulatory architecture. We should invite knowledgeable and value-driven non-lawyers to sit with us in our regulatory bodies. I thank you for listening.
Let's give him another round of applause, please. You know, this afternoon, I noticed a young boy, walking behind Mr. Alex Moka and Baba. And he was saying, words and opposite, words and opposite. And I was concerned. I said, what's happening in our primary schools? A young boy doesn't know the difference between a man and a woman, until I saw that he was pointing at their hair. So, all right. So let's take the final speaker, who will be speaking for, and let's welcome Daniel Bwala.
Should we continue to self-regulate? Those who are against self-regulation are promoting the invasion of the state security services in the homes of judges, and consequently, armored tankers are going to be in the homes of lawyers. Should we self-regulate? I say yes, but I will say yes because I will ask the question, the immunity of the human body, is it better than medication? My answer is yes. Because medical science has proven that no matter how effective a drug or a medication is, as soon as it gets into the system, it is still a poison. But that the human nature, by composition, has the infinite capacity of cleansing itself, resisting external bodies, and getting the man going. The legal practice is the only hope of the common man. The legal practice or the legal profession is the only platform on which the institution of the state is put in check. The accountants provide accounting service, but they do not hold government to account. The quantity surveyors do the same. Even the medical doctors, they can go only as far as curing or managing ailments. But the duty of a lawyer, as provided in Rules 1, is to promote, to observe the rule of law, promote the cause of justice, and not to be engaged in any conduct that is unbecoming of a lawyer. All over the world, and I say that because in America, for example, you need to have, if you're doing the New York bar, you need 665 points, constituting about 80 or 85% of the overall score to be admitted to practice. All other professions are not like that. In England and Wales, and I'm privileged to be admitted there, when I sat for my bar exams, in sections 4 and 5, which deals with rules of professional conduct, it is not a textbooks-based exam. You appear before judges. They ask you questions regarding professional conduct, and you have to pass before you will be admitted. Section 5 is witness handling, and in some cases, cross-examination. This kind of services cannot be provided by somebody who is not a legal practitioner. Should we continue to self-regulate? The lawyers or the legal profession determines even the entrance into the profession. You have to have your LLB. Whether you're a criminal or you are knowledgeable, you have to have it. And then you have to go to the law school. We are not just your knowledge is tested, but your character and your learning. And I'm privileged to teach in the law school, to have taught in the law school. When we had our portfolio assessment, part of the problems that students complain about chambers, and I make bold to tell you today, the chambers are not doing enough. And that's why I support the idea of reform of the legal profession by lawyers and not regulation by government. They say oftentimes when they go to chambers, most of the law firms do not have time for them. They are relegated to the library. And so they end up reading for the exams. But I observe that 70% of what will be required for them to pass the exams are things they can learn in chambers. For example, drafting of charges, drafting of pleadings, witness handling, and so many other aspects of corporate law practice. But that the profession is not in itself helping. That is why I support the idea of a reform by the legal profession and not regulation by the government. If the legal practice or profession is allowed, if we allow government regulation, it means we are going to come to a meeting just like in the Bar Standards Board in England, where the members constituting the board are majority of non-lawyers. And right now, there is a serious discussion in England whether the regulation by the government is actually helpful or suicidal to the practice of law in England and Wales. Should we self-regulate? I hold the view that we need reform in our practice of law. We need to look at the issue of minimum wage for legal practitioners. We cannot shy away from it. We need to promote the idea of merger of law firms. Many years ago, I heard of a law firm they called Templars. And where I was, all that I heard people talking about Templars, they are talking about, I want to apply to go to Templars because they pay well. That is what we need, and we don't need no government to come to Templars and tell Templars what to do. Only a legal practitioner understands. They say, he who wears the shoes knows where it pinches. When you live in a society where the institutions are not strengthened, where corruption can find its way right to the top, and you allow a nation with this kind of corrupt system to regulate the practice of law, then the interest of client, whether private interest or commercial interest, will be in jeopardy. If we allow government to regulate the legal practice, it means XYZ senior advocate that appears for ABC politician, his house can be invaded, he can be found wanting, and he can be prosecuted because he defended somebody who is out against the interests of the government. So self-regulation is the key. However, self-regulation means reform. Self-regulation means look at the way in which advocacy is promoted in the practice of law. Because ultimately, the client has the control over the type of services he gets. There is no regulation in our practice that stops a client from debriefing a lawyer in the middle of the case and giving it to somebody that will provide a better service. And we have seen in our lifetime how that clients debrief senior advocates and brief non-senior advocates. This is a profession that permits for the client to exercise his option of selecting the services he gets from a lawyer. Because the idea of regulation deals with promoting the reputation of the lawyer as an individual and the reputation of the legal profession as a people. And we also have the power of exclusivity. Any lawyer that is found wanting will be disciplined. I make bold to ask, have we been disciplining lawyers? The answer is quite in the affirmative. Every day you hear of disciplinary procedure against lawyers. Sometimes lawyers are disbarred. Even judges are suspended and in some cases dismissed. The profession does not need EFCC to determine the conduct and practices of the legal profession. The profession does not need the Department of State Services to tell us how to handle matters in court. So I say in finality, the only way the profession can improve its service, can defend the integrity and the independence of the institution, is when that profession regulates itself. We don't need government intervention. Thank you.
I remember Dr. Gamawa last year, and I know that earlier when I saw Mr. Bwala in the lounge, I said to him, "You're very quiet, sir. You haven't said a word." People like you, when it comes to debate, they're very dangerous. May I have a round of applause for Mr. Bwala, please? It's been a very interesting and stimulating debate. Correct me if I'm wrong. Ladies and gentlemen, have you enjoyed this afternoon? Yes. If you have truly enjoyed this afternoon, could I hear you say aye? Aye. And if it's been a thorough waste of your time, and Olu's just been getting this thing wrong over and over again, let's just hear you say nay. And they pay very well, don't they? Joke?
Okay, so let's take the votes on the final topic. Those in favor of Daniel Bwala say aye. And those in favor of Alex Moka say nay.
Right, you guys are very confusing. Alex, the definition of insanity again is when you do the same thing over and over and over again and expect, yeah. So, Alex has said, let's mix it up a little, bring in maybe a couple of accountants, get rid of all these dodgy lawyers when we're disciplining each other. Because the truth is, you're my friend is your friend, a friend of a friend, Ime Madu somewhere, man no man. We're not really going to do it right. So, can we be honest? Should we continue to self-regulate? If you believe so, say aye. If you think that independently we need some third-party experts when we have disciplinary panels to actually enforce and instill discipline in this profession to put us in order, be sincere with yourselves and let me hear you say aye. The ayes have it. Ladies and gentlemen, you've been fantastic. So we've had 4 topics, and we're just wrapping up now. The first topic, should Nigeria accede? No, the first topic actually was, should there be ladies at the bar?
Yes.
Am I correct?
Yes.
And what was the judgment of the House?
Yes. Yes.
So, there will be no ladies at the bar. The ayes have it. The second topic, Joke, was?
The second topic was about acceding to the African Continental Free Trade Area.
Yes. That's where we had Ikechukwu, Ibiawuchi, and Kalu.
That's where we had all those wonderful examples that
Kalu gave. 3, to be specific. Monica, the husband and wife, and Red Sweater. Kalu, really. So, Should we sign this treaty or not? The giant of Africa, or are we just one of those small African nations that make up that horn of Africa? Ladies and gentlemen, should Nigeria sign the treaty?
Yes, have it.
You belong to the Senate.
I think the yes have it.
So the yes have that. And the third item was pupillage,
Yes.
I believe. And that was a very, very tight race. We had Isaiah on the one hand, and I'm going to be transparent. I don't know if anyone can see my brochure here. I had boxed Isaiah as, home run is gone. I didn't even bother listening to you guys. Oh, it's done. Then she came up to the lectern, and I'm like, okay, well, you better circle that one too. So, Cordelia Eke, prosecutor of note, not very popular with her job, but she gets the job done, has said to this house that pupillage, please, let me repeat her words. She didn't say we shouldn't have pupillage. She said it must not be mandatory. Those were her words. And she said to make it, I can't hear you. And if you believe that it should be made attractive and not mandatory, could I hear aye? The other vote?
All right. If you agree with Isaiah and you believe that it should be made mandatory, can I hear aye? Aye.
I am going to give the casting votes to none other than Mr. George Etomi. Uncle George, who's got it? And the last item, Joke, would you please take that?
Yes. Should lawyers self-regulate? I mean, when you see a lecturer talking, you can tell with the passion and, the gesticulation and all that. So those in favor of the position that lawyers should continue to take the responsibility of self-regulating, say aye. And those in favor of the position that we should leave it to third parties like the EFCC.
Joke, really? Joke, no. I mean, that's not right. Come on. What is wrong is not right. Why are you getting the EFCC involved here?
The DSS.
Tanks.
The ICPC.
APC.
Say aye.
So do we take it that that argument was won by Mr. Daniel Bwala? Ladies and gentlemen, it has been a splendid evening. We do not want to continue to keep you away from Davido. The lights have dimmed. You've been a fantastic crowd. We thank you for listening. We thank you for participating. They've been fantastic, our debaters. A round of applause for all 8 of them, please.
So we'll hand back to the coordinator of the session.
I promised you it was going to be fun. A big round of applause to our sponsors. A big round of applause to the moderators and the panelists. I would like to welcome on stage the chairman of the NBA, Section on Business Law. You ought to give your vote of thanks. Vote of thanks, sorry.
There's no vote of thanks. We'll do 2 things. We can't self-regulate, so I beg. Alex, I'm with you on that one. But distinguished ladies and gentlemen, we don't have that much time. We're going to close shop very quickly, but it has been exciting, and it's still a packed hall. Fantastic. Can I call on the founding chairman of the Nigeria Bar Association, section on business law, Mr. George Etomi. You know, many of you know my biases when it comes to George Etomi, because Nami give and wife. So he's my big brother and my brother-in-law, but he's founding chairman of the section, of whom we're very proud. George Etomi will help us with 2 tasks. Firstly, sir, if you kindly present gifts to the debaters and our fantastic moderators, Baba and Joker. Thank you so much. And of course, after that, we have something else we want to do, something special. So if I may ask, starting from, yes. Balaji, you have to, they want to catch you. Kodak moment. I have to do it again. Should there be ladies at the bar? We should have that conversation again. Thank you, Isaiah. Thank you, Mr. Boala. Thank you, Red Sweater, sorry. Thank you, Kalu. Thank you, Joker. Baritone Babashola. Thank you. Thank you, Ikechukwu. Thank you, Alex. I stand with Alex. Hashtag. Thank you, Cordelia. Immediate past secretary, MBA Port Harcourt. Thank you. And chip off the old block in many ways, more than one. Paul Dowdu, thank you. Thank you, Brother G. Brother G, can you wait, please? In the course of planning the 11th SBL conference, the SBL family suffered a tragedy. We lost our friend and our sister, Oyintare Yeri, who had been a member of the planning committee of pretty much every one of the SBL conferences up until last year. She was indeed a member of the conference planning last year, and unfortunately she passed on in California while we were planning the conference. To say the least, we were devastated, but I think we survived it, and then we decided to institute an award in her memory and in honor of her memory. We did that last year, and we called it, or we named it, the Tari Yeri Star Award to the most deserving young lawyer who has worked hard to support the work and the projects of the section of business law. And the recipient last year, without a shadow, sorry, we must use a confusing language, without a scintilla of doubt, was Mrs. Yetunde Okoje, who I have asked to bring for me now the award that will be presented to the winner for this year. So, thank you, Yetunde. Careful. Thank you. So, Brother G, sorry, Mr. Etomi. we thought hard and long about it, but in the course of the almost 2 years that I've been chairman, there's one person among the young lawyers who works so hard with us and for us, who, when I turn and look behind, is always there. And that person, I will not go into gender yet so I can keep the suspense going. That person is devoted, is committed, is hardworking, and I said is. I said is. Is hardworking and has always, and she has always been there for the section for as long as I can remember. And even Mr. Itomi will attest to that fact. And just to give you a hint, it was her birthday 2 days ago. Miss Theodora Kyo Lawson. This award comes with a 500,000 naira cash prize contributed or donated by the law firm of Dorothy Ufot and Co. How Theodora does it, I don't know. How she holds down her job with Business Day and still manages to deal with the issues, the many issues that confront us as a section, as chairman of our media committee, and then she does every other thing. Please, a round of applause for Theodora. And Theodora, thank you very much. Can I now ask that you please give a round of applause, an unceasing round of applause, at least until they all come forward, the members of the Conference Planning Committee. Every member of the Conference Planning Committee, please. Fantastic people, devoted people, committed people, inspiring people, led by our Duracell bunny, Okay Buchu, whose energy is boundless, who leads from the front, who gave such inspiring leadership to this group, and who made it happen, ably assisted by Dr. Adeoye Adefulu. And then our Chancellor of the Exchequer. I hope she's in the room or she's in the lineup. Absolutely. Mrs. Chinyere Okorocha. Olu, what kind of work have you given me? You know me, my practice is IP. I don't know people. I say you will do it. And she has done it. And she's still doing it. She's still raising money. She says she will continue raising money tomorrow for the conference. But Chinyere, on behalf of all of us, because if we did not get sponsorship, this would not be possible. On behalf of all of us, you had pretty big shoes to fill because Maima Bello Sagi had done this 2 years running and she had done such a great job. But you did fantastic. Chinyere Okorocha, we are still tallying the numbers and we're still making last-minute calls to hopefully they will not be reneging, but we are still calling the donors. But as a last count, cash in hand, Chinyere crossed the 200 million naira mark. But of course, she did not do it alone, and I'm sure she's also extremely grateful to those who worked with her. But I want to single out for particular mention the members of the LOC in the TCPC. I'm rhyming. I mean, I'm rhyming. The LOC in the TCPC, the Kaduna-based members of the TCPC. I'm sorry, the Abuja-based members of the TCPC. I am so grateful to you. And sometimes it's hard. There was a bit of a disconnect. We were in Lagos, they were here, but they made it happen for us here. And we're very grateful to you. So, one more round of applause for these fantastic people. My big brother is coming to tell me something I've done wrong or I haven't done. Okay, of course. I would ask two things. Okay would very quickly speak on behalf of TCPC, and then, okay, please, you hand over to Mr. Tomi. He has an announcement to make. Microphone for okay. Yes, oh, I'm so sorry. Okay, before you speak, can you imagine? This is false imprisonment. A round of applause for our debaters and the moderators. Oh, okay, TCPC, you wait there. Please.
George. Conference Planning Committee. I'm so proud of all of you. I'm almost in, if not that I'm a man, I would have started crying right here now. I troubled all of you, drove all of you mad with my tempo, but nobody held anything against me. You all encouraged me. I will kill you now. You are such a wonderful family, and I'm so proud of all of you. Without you, this conference would not have held. And I will never forget each and every one of you. The youngest of you, you are wonderful. Tejiri, I must mention you in particular. Her first time of doing such a thing, and she acted like a professional. The feedback is not from me, it's from all of you, those who work with her, from the coordinators, from some of the panelists. I said, who is that? You have a hot person there. So I said, wow. I didn't know what they meant by hot. It was when I heard it from the women I knew that it was genuine. So we are extremely proud to have organized this conference. And if you are happy with what we have done, say aye. No other question for you. So all I can say is thank you, and thank the council and Mr. Kwata in particular for giving us the opportunity. And I look forward to all of you taking it to the next level next year to make it even better, because some of you will still be part of us. Chinyen, I bow before you. Up you! She raised all this money in 3 months. 3 months only. She kept on crying, worrying. Luckily, she got encouragement from those who had done it before. Dr. Maima Bello Osage, Ms. Fayoku, who also made calls that assisted her in meeting the over 200 million she has done today. Ms. Fayoku, thank you. As a silent member of the CPC. And Maima, too, who is not here, who also made several calls to raise money. All of you, we harassed to help us raise money and talk to your contacts that are in this hall or not in this hall. We thank you. Some of them answered us, some did not, but we appreciate the effort of all of you. Thank you, TCPC. CPC. MBA wants to corrupt us. I thank you, Endurance, our great administrator. How he does it, I don't know. Endurance. He hasn't collapsed in the past 3 or 4 years. It's a mystery. I'm coming. Now waiting. You women are so aggressive these days, though. Harassing me for panels that I consulted that 2 people pulled out of. Please, I love women, I love women. You can see there are more women than men here. Nana, you too. I don't know what to say. I call her every time, yes, sir. I will do so, sir. Yes, sir. And she does it. Few mistakes. If there were any errors by any of us, any glitches, I accept full responsibility. Freedom. It's me, I'm fault. Blame me, leave them alone. I am in charge, I am the leader, so I beg forgiveness for any glitches. Thank you, committee. You can take your seat, please. Bless you. All of you know that Mr. Oluwapata, this is the last SBL conference that he will preside over. He will hand over in August to another executive. If you think that, you all heard what happened, his efforts, his successes, the results he has achieved in the past 2 years, both at the dinner and even during the conference. If you agree that Mr. Akpata has done so well, please stand up and give him an unceasing round of applause. You can slow it down now. I know you want to clap till tomorrow, or you can slow it down. Slow it down. Thank you. The man is totally deserving of this. It was a handover to a generation when he became the chairman of SBL. Waigons were chairman in succession. Then there was a gap, and they came to Olu. And it shows that he learned from the time he was secretary, vice chairman, and now he became chairman. So he was well prepared for the job, so if he had failed, it would have been a disaster. And it would have been wrong and bad for the generation that he got that opportunity and he messed it up. But no, he has elevated the SBL. You heard the president of the bar say so yesterday, on Wednesday at the dinner. We have many new programs, and I am sure the person coming to take charge next time would also raise the bar. Like we all do every time, we always raise the bar. This conference will be better next year because that is how we always are. And we all work together to achieve that. Now, I thank all of you who have been here for the past He wants to do.
May I thank the chairman of the SBL for this opportunity to address you. I'm not going to bore you, but so many good things have been said about the section on business law, and I'm so proud of what you have all done, especially building on the foundation that has been laid. It's so easy to deviate from what was originally the dream. But we are just a section of the Nigerian Bar Association, and we still owe a duty to the parent body to support all its activities. I'm delighted to inform you that I have been appointed the chairman of the Conference Planning Committee for the 2018 Annual General Conference. And I want to leverage on all you good people in the section Business Law to make sure that we produce at the level of the parent body what we've been able to produce here. This year's conference will hold from August 26th to the 30th, and it will be here in Abuja at the International Conference Center. The theme for this year's conference is Transition, Transformation, and Sustainable Institutions. I know what you feel, but we had coined this before the confusion. And we had a debate whether or not to change it, but we said we should stick to the original script. Now, we also have a number of sub-themes. I'm not going to bother you with the sub-themes, but we're going to try and cover the field because we're a much larger body. We're looking at governance issues, we're looking at security, we're looking at diversity and inclusion, we're looking at the profession itself. We have the distinct honor of having the President of the Republic of Ghana coming to give the keynote address on the opening day. It will be followed by a one-on-one conversation with our President, and then on the same day, we're going to have the immediate past Head of State, General Abubakar, discuss the issue of transition. As we all know, we acknowledge him as one of the officer gentlemen who honored the transition and midwifed a transition that stayed rigid to the program that he set. Even though he was under pressure to extend it, he said he would do it. And today he's the beacon of hope in the entire continent and goes around talking about the values of smooth transition. Now, on the business front, we are going to have quite a number of business mongols talk to us about their experiences. But what is critical for me is the take-home for us lawyers. We are the hosts. We're going to play host to nearly 10,000 delegates. So even though this is a large conference, you can imagine having a number 10 times this size. So it behoves on every one of us to ensure that we play the perfect hosts to most of our international guests who will be coming. We look forward to copying a lot from the SBL. We're not ashamed to do that because you are part and parcel of the NBA. And the SBL has actually become the poster child of the NBA when it comes to standards and conferences. So I look forward to support from every one of you because I'm one of you. We need to continue to push the limits, continue to raise the standards, continue this quest for relentless pursuit of excellence, because that's the only way we can be relevant, that's the only way we can take advantage of a changing world. The world order continues to change. I need not tell you what is now going on. Nobody can decipher today what's happening. Donald Trump has totally upstaged every notion that we thought was settled. But today we see that the only way you can take advantage and do the best is to prepare yourselves. Charity, they say, begins at home. So on that note, I want to invite every one of you. The early bird registration is open until July 31st. And there's going to be so much you get for that early bird. I urge every one of you to push. If there are any questions, we have a functional website that's very interactive, very friendly, and you can ask the questions and to be all dealt with. So I look forward to seeing all of you back in Abuja in August this year. Thank you very much.
We can't have a conference without putting all the parts together. And a conference is an assembly plant. the CPC, the sponsors are the fuel. The coordinators are the artisans who make sure that each session is well run. The delegates come to the party, without whom we waste, all our efforts are to waste. The service providers provide all the facilities that we need and use to make the conference a reality. The media, especially, help us bring you wherever we are holding the event. I am grateful to all of you. You have all been wonderful. No, you have all been excellent. Every single person that participated in making this a reality went beyond the call of duty. There was no reward. I must mention two particular persons. Kuna Ajagbe, who prepared the program, who designed this program, this wonderful program you see, with myself and Olu on his neck, and Dioye, the deputy chairman, we're on his neck. He never complained. He designed, we came with the idea of the thing, but he refined it to what you see now. He, in fact, designed most of the topics. In fact, the debate session, he probably designed 2 of the topics. And you saw how interesting it was. So, Kule, I am very grateful. Chinyere has sneaked out. She has to attend to a few things, like I must thank her again. Fundraising and designing the program are the core of organizing a conference. Up till yesterday, we were still changing panelists and moderators because some people pulled out at the last moment for one reason or the other. But somehow, by the grace of God, we're able to bring people of the same caliber to make that up. Of course, council members, and especially Olu Akpata himself, was there. Although this time he begged me that he will abandon me for a while because he became Pope John Paul, traveling all over the world, preaching his sermons. This was the most abandoned CPC in the history of conference planning. But he begged me, he said, oh boy, you're on your own, but I will contribute. Eh? So Olu, we forgive you for your absences. Delegates, you've been wonderful. We have a full house after 6. Come back by 8 o'clock with your delegate tag and dance to Davido and enjoy till daybreak. Thank you, and bye-bye.
Closing ceremony of the 12th Annual Business World Conference, holding at the Transport Theatre of Abuja, Nigeria on the 29th of June 2018. For registration and other inquiries, visit www.ngasdlconference.org. Join the conversation on social media with the hashtag NGASDL2018. We look forward to seeing you there. Come party with David Hill, the original Omobahara himself, at the closing ceremony of the 12th Annual Business World Conference, holding at